Department of Medicine, Health, and Society. And I'm also the director of our LGBTQ Plus Policy Lab, which is co-sponsoring this event with the Dean's Office at the Law School. It is my great pleasure to introduce your speakers for today. The first is your very own Danielle Berteau, who is a JD candidate here and president of OutLaw. She's also previously worked in the humanitarian space for protection of LGBTQ plus children and families. Welcome, Danielle.
Thanks.
Thank you. You got the crowd on your side here. And then it is also my great pleasure to introduce to you Omar Gonzalez-Pagan, who is senior counsel and healthcare strategist at Lambda Legal, one of the oldest LGBTQ rights organizations in the country. Omar has been part of the legal team for Obergefell v. Hodges, several other cases like Bostock that you've likely heard of and studied, and also lead counsel on cases instrumental to achieving marriage equality. Join me in welcoming Omar. Thank you.
Well, thank you so much for joining us today, Omar. I think I speak for every person in this room and even people who are not able to join us today that we are extremely grateful for your work, your dedication to something that is deeply important and affecting the lives of so many people in so many different ways. So we're very fortunate to have you here with us and are looking forward to this really important conversation. Thank you.
Thank you. Thank you. And an honor to be here. Thank you. Tennessee in many ways is an epicenter of the fight for LGBTQ rights in our country. And Vanderbilt has played a central role in educating the state, our country more broadly about what's at stake. I've had experts that have come from Vanderbilt. I've had clients that have come from Vanderbilt. And so happy to be here and be able to speak with all of you.
Yeah. So I'll start out, and just to keep in everyone's minds, we'll have time for questions. So feel welcome to write down any ideas or any questions as we're going throughout the discussion for the period. And after this, we will have a smaller coffee chat right in Birch, which is across the way. So if you want to have any more conversation, Omar has really graciously dedicated even more time to our community. But I'll start out. So the past year, we've obviously seen a ton of developments affecting the rights of LGBTQ people. Can you walk us through some of those challenges that the community has faced over the past year?
Yeah, absolutely. I think we need to keep in mind that the history of LGBTQ rights is not linear. In fact, the history of civil rights, generally speaking, is not linear. There's ebbs and flows, and we're in a moment of what we would call retrenchment. And we're facing attacks like we've faced them before. They come in waves. So, for example, the marriage bans all came in waves in the early 2000s. Thereafter, it was attacks on the ability to use the restroom, and there were a ton of bathroom bills that were happening post-Obergefell. And then after Bostock, a lot of attacks with regards to healthcare. And what we're seeing now is a broader attack, reminiscent of the days of Anita Bryant, for those of you who may recall. The early struggle for the fight for LGBTQ equality. What we're seeing in the last year is the federalization of what have been attacks that we were seeing already in several states. Among those, particularly were Texas, Missouri, Florida, and to some degree Tennessee, where the attacks against LGBTQ people were broad-based and with a particular focus on transgender people, ability to live in society as who they are. And so the last year has been, with the new administration, the federalization or nationalization of those attacks. And we have continued to see these attacks at the state level. But we've also seen now several executive orders, federal agency actions that attack LGBTQ people on frankly, broadly across the federal government, and I'll get into some of those details, but they go from education, healthcare, employment, identity documents, and the like, housing, And you see the obstacles being raised as obstacles trying to prevent people from being recognized as who they are in society and from, frankly, the imposition of gender norms across society. We'll talk a little bit more about this, but at the end of the day, the attacks that we're seeing against LGBTQ people, and particularly transgender people, go hand in hand with the imposition of gender norms. And I think this is why women's equality, LGBTQ rights, and frankly, personal autonomy for anybody go hand in hand. And when you see the attacks that we're facing in the LGBTQ community, you can see how those can be translated to and can lead to the erosion of the rights of women and our rights more broadly, to be able to have freedom, individual freedom, to make the decisions about who we are, how we want to live. What have those attacks been looking like? We have seen executive orders that target transgender adolescents and young adults with regards to healthcare, their ability to participate in sports, their ability to be respected in their schools. We have seen what I will call the gender order, and this is the so-called Defending Women executive order that was issued on day one of the current administration. Mind you, President Trump was just getting done being sworn in at noon on January 20th, 2025. And that afternoon, one of the first executive orders that he issued was an executive order, the so-called Defending Women order, or what we call the gender order, that does the following. It is a broad-based attack on what the administration calls gender ideology, and we'll talk a little bit about what that is. But it attacks, it eliminates protections that existed at a regulatory and executive level for LGBTQ people. It seeks to cabin the Supreme Court's decision in Bostock, and it imposes obstacles for federal employees to participate as themselves in their employment at the federal level and in federal agencies. And it has a whole other host of aspects to it, including what we'll talk, which is the use of federal funding as a, frankly, tool of coercion in our country now.
Yeah. Thank you for starting us off on that. So as you've mentioned, it seems like a lot of these attacks relate to the current administration's desire to combat what it terms gender ideology. Can you share a little bit more with me your take on that?
Yeah. So gender ideology is not a thing. It is a made-up term. You can look it up in Project 2025 by the Heritage Foundation that is now used by opponents of LGBTQ rights to attack the very existence of transgender people. So the gender order defines gender ideology as believing or recognizing that a person can be of the sex other than their birth sex. And it actually terms that to be a false claim and a false belief. What does that mean? That is the very definition of somebody who is transgender, is somebody who is of the gender, the sex, that is incongruent with the sex that they were assigned at birth. And mind all of the intricacies of what is sex. Big question, and I don't think lawyers are the best equipped to do that. But the reality is that there are a multitude of aspects to what is sex. Our hormones, our physical characteristics, and our ability to reproduce, and more importantly, our brain, which is influenced by a number of things. And so there are this whole host of characteristics, and the gender order tries to define being male or female in very simplistic, frankly, unscientific ways. They tie reproduction and the ability to recognize somebody as male and female as being obtained at the moment of conception, and all doctors will tell you that's not when that happens. There is a lot of development, that a fetal development that needs to occur before that occurs. And so what it seeks to do is erase the very existence of transgender people by labeling being transgender as a false claim, a false belief. It seeks to eliminate or reject the very idea that transgender people exist. And as a consequence of that, it says that the federal government will not recognize somebody's sex as only limited to their, will only recognize somebody's sex as limited to their birth sex on passports, federal identity documents. For federal employees, it now requires them to serve in accordance with their birth sex, meaning they cannot change their pronouns on their emails, and they cannot be referred to in a manner that is respectful of their identity when at work. Mind you, this is completely contrary to Bostock, right? Bostock was an employment case, mind you. It dictates that no federal funding will be provided, this is on the gender order, to any entity that promotes gender ideology. What does that mean? It means no federal funding for any entity that recognizes a transgender person's identity as who they are. That's what that means. And I tell you that because I've been in court where the Department of Justice attorneys have actually said, when asked by the judge, does this mean that a recipient of federal funding cannot use the pronouns that are consistent with a transgender person's identity? And the response is yes. That's what that means. It is the use of federal funding to coerce a point of view that is discriminatory, anachronistic, on all of American society. It is the imposition of a particular point of view that is not shared by most people, and that it conditions our ability to receive and participate in society because of federal funding on that regard. And why does it matter? Federal funding is huge. All of our schools public schools receive federal funding. All of our hospitals receive federal funding because they give services to people who are on Medicare or Medicaid. That is federal funding. And so if your town receives funding with regards to just building a road, with regards to asphalts, it already limits, all of those things. And so you see this erosion of the recognition of people's identity under the guise of gender ideology. There are similar other attacks that are happening. Just yesterday, there were votes to override the veto of a law that is being proposed in Kansas that would actually criminalize transgender people's use of the restroom by putting a bounty on them. And it actually says that if you see someone of the opposite sex in the restroom, sex being defined as their birth sex, you actually can sue the public entity in which the bathroom that was, but also sue the person for using the restroom. And then it also goes even further and says that all of the birth certificates that were issued under a consent decree that we had secured in 2019 that correct the gender marker on the birth certificate, or all of the driver's licenses that have a correct gender marker for a transgender person are hereby declared invalid, and that the state will issue new birth certificates and driver's licenses that are reflecting of their birth sex and not their identity. So it's actually going back in time to erase people's identities with regards to their identity documents. I want to add that under the guise of gender ideology, right, they're erasing transgender people's identities, but this relates to gender norms. How so? When you go to the restroom, let me tell you, you have no idea who is trans or not. You won't. And so what that means is that for most people, if you're gender non-conforming in any way, as compared to somebody else's expectations of how people who are male or female should dress, behave, or look, your privacy is now going to be invaded because there's an incentive, a literal monetary incentive, to kick you out of the bathroom. That is a scary world to live in for anybody, LGBTQ or not. And we have seen this play out, right? In other states where they have passed bathroom laws, we have seen cisgender women who somebody don't believe are sufficiently feminine be kicked out of restrooms physically and assaulted as a result of that. I also want to put some perspective here. I was just looking at the numbers from Gallup most recently, the other day. The LGBTQ population is and remains, however popular or cool we like to pretend to be, fairly small. No more than 10% of the population in the United States is LGBTQ. Half of that are bisexual people. The other 5%, about 2 point something, are gay people, gay men, similar to point something lesbians, and then 1% of people in the United States is and remains. This number has been steady. It has never been above this. Despite all of the crazy articles that you read in supposedly mainstream media, and I have my own fight with the New York Times, less than 1% of people are transgender people. Of that number, the people who get access to care because of means and opportunity is even smaller. And the people who actually are open about their transgender status is equally as small. That's what we're talking about. It is about attacking less than 1% of the American population. The administration has issued over 6 executive orders focused on this issue. And mind you, that's just executive orders, not all of the other regulatory acts. When you think about our country's problems, there's a disconnect here. Why are you focusing on attacking less than 1% of the population when we have such big issues to deal with in our country and as a society? And then you know what the answer is. This is not about seeking solutions. This is not about addressing issues when it's meant to be used. This is about discrimination and imposition of norms. And that is what we like to call animus. There's no other explanation for this other than that.
Thank you so much. So obviously there is so much to unpack here. You mentioned that you were in court the other day, so I'm hoping you can share with me a little bit more about the fights against the gender order and against these attacks that you've been describing.
Yeah. So we talked a little bit about these attacks, and you're talking about the efforts to fight back against these attacks. Well, we're busy. The effort is multi-pronged, and it is done in coalition and with community. What do I mean by that? The amount of stuff that is being thrown at us every day will make your head explode. It really will. There's not one day that I'm like, pardon the language, God damn it, what is happening? Right? Or some other expletive. Because they try to throw everything at us every single day in ways that are unprecedented and in ways that we didn't even expect. So how do we fight back? The courts are incredibly important. I'm a civil rights lawyer. I'm an LGBTQ rights lawyer because I believe in the promise of our Constitution. I really do. No matter the court composition, at the end of the day, I believe, sometimes I think the Supreme Court, and it's okay to say this, gets it wrong. But I believe in the promise of our Constitution. And I believe in the promise of the law. But it is not the only tool that we have, and it will not be the only way that we can solve all of our problems. What are we doing I'm a litigator. In the last year alone, we've sued the administration 7 times at Lambda Legal. I will add that other organizations, like I mentioned, We're Working Coalition and Community, have also sued the administration over similar, same, or other policies. And we do this in coordination. And I will add that several states' attorneys general continue to work in coalition to do the same, and we work with them to address these issues. I was talking with a colleague just 2 weeks ago at the Massachusetts Attorney General's office, and they're like, we've brought 47 actions against the administration so far. They were counting amicus briefs, which is, I think, a little bit shadowy, but they've brought a lot of lawsuits as well. So we continue to fight back with the courts. What are the cases that we have brought? We sued over the imposition of the gender order. Recall I mentioned that provision that requires that any federal funding be tied to not be used for the promotion of gender ideology. There were other executive orders that somewhat relate to these issues, like the DEI orders, which prohibit the promotion or use of federal funds to address equity in any aspect of society. And so that may pertain to housing programs, domestic violence programs, it may pertain to social justice programs, it may pertain to healthcare programs. So we sued the administration on behalf of a coalition of LGBTQ community centers and organizations. These were federally qualified health centers. These include the GLBTQ Historical Society. These include entity in Wisconsin and entity in Maryland, Forge, that they actually provide services for victims of domestic violence and a focus on the LGBTQ community in that regard. And so we were able to sue on their behalf and obtain an injunction that protects them from the termination of funding with regards to if that funding pertains to under the gender ideology order or the DEI orders. And it also explained how several statutes actually require that the funds be spent for example, addressing the needs of underserved communities or addressing the needs of gender minorities. And that is spelled out in the statutes passed by Congress. So we obtained that injunction on behalf of this coalition of groups. This is a case in where the lead plaintiffs is the San Francisco AIDS Foundation. We represent the New York LGBT Center, the LA LGBT Center, and the like. We have a similar other case pending in DC on behalf of the Chicago AIDS Foundation as well. We sued the administration over its ban on any person who is transgender serving in the military. We were able to obtain an injunction that lasted a few months. Unfortunately, the Supreme Court stayed that injunction, but that case is still moving forward. That's the call I was in before I got here to speak with you all. We're moving in that case moving forward. We were able to sue and had to sue with regards to what we will call the denial of care order, or what they like to call the child mutilation order, where they prohibit any funding for any entity that provides gender-affirming medical care to a minor, actually, or young adult, because it's under 19, and they keep moving those goalposts, right? They're not even focused on minors, now it's under 19. We have seen now a statute in Puerto Rico that moves the goalpost to 21. We were able to obtain that injunction. That was incredibly important, by the way. In that case, we moved heaven and earth within 1 week of the executive order being issued on January 28th. We sued on February 4th. In that case, we had hospitals that immediately following the issuance of the executive order were shutting down all their programs. Mind you, this is in states where this care is legal, right? Unlike here, where you had the case out of Scrimeti that was decided last year. This is in states where it was legal, hospitals are operating according to the law, standard of care in those states, but they were shutting down their programs because, again, using federal funding as a tool of coercion. If you provide this care, we're going to take away all of your federal funding such that you cannot serve any of the people that you serve. These are, for the most part, children's hospitals. And so this is about taking, where you abandon this 300 or 400 patients or the thousands of children that you care for will not be able to be cared for. I want to just add a name that tools of coercion like this is not what government does, it's what the mafia does. And so this is how our government now behaves. We were able to get an injunction put in place, and several hospitals restarted their programs. And we'll talk a little bit more about this in a few questions, but unfortunately, that is now going back again. But that injunction remains in place. Also, one of the few last nationwide injunctions, but it's still in place as a nationwide injunction, despite Casa v. Trump being decided last year by the Supreme Court. And then we also challenge the case, the policy emanating from the gender order with regards to passports. We have an injunction that still is in place with regards to our plaintiffs. We challenge the denial of NIH funding for LGBTQI research. That injunction is in place even today. And we just, on Tuesday this week, challenge the removal of the pride flag from the Stonewall National Monument. So that's a challenge that we just filed on Tuesday. Let me just pause there about how insane that is. About how a monument, which by definition is supposed to reflect and honor the values of the LGBTQ community, is being slowly shipped away by taking away the pride flag, removing any mentions of transgender people, et cetera. And I just want to add, obviously I work mostly in the LGBTQI sphere, but this is being done with regards to all minorities. The same is being done in Philadelphia with regards to any recognition or mention about slavery in some of the historical sites surrounding the National Historic Site there, the Constitution Historical Site in Philadelphia. And there was an injunction issued, I think purposely on President's Day by the judge, calling out the removal of these inscriptions and exhibits that recognize the history, the part that slavery played in our history in regard to those monuments, including the president's house at the time. And so these attacks are attacks of erasure. It's about, frankly, snowflakes wanting to feel better about themselves by erasing their bad history. But that's who we are as a people. That's how we grow as a people. We cannot grow if we cannot recognize our faults in our history as a society and as our community. And by erasing these very acts of discrimination and why these monuments have to exist, including the Stonewall National Monument, we're trying to erase those moments in time in which the government was not a force for good, but a force for evil, in which our institutions were not a force for good, but of oppression. And that's what we're fighting back right now with these cases. I will add that there are also other efforts, right? Political efforts, advocacy efforts. Sometimes pressure does work. Not often with this administration, but sometimes it does. And something can be sufficiently politically unpopular that they may reverse course. And then trying to come up with other solutions by our partners, working with states to adopt what we call sanctuary laws with regards to healthcare for reproductive care and gender-affirming medical care. Those are new laws that have come into place in the last 2 years to protect people post-Dobbs and post-Cremetti from having their health records be obtained, from having providers in those states that allow that care be brought into bad states for lawsuits, et cetera. So those are some of the ways in which we're fighting back. I will add that, personally I'm involved in 6 lawsuits against the Trump administration, and we have 4 injunctions, and of those, and 4 injunctions remain in place. So that is, I think, a good thing right now. There's a lot of ups and downs, but we've been able to at least stop most of the harms that we can. I'll be honest, we're in a world in which, I mentioned we're in a time of retrenchment. We're in a world in which right now we're seeking to prevent harm. A lot of these cases are not being brought with the idea of let's establish this big precedent and big doctrine, which is a lot of what we used to do as impact litigation, right? Small cases building to that big win that led to marriage equality. Small cases that lead to those precedents that lead to Bostock. Right now, we're fighting for our lives because that's literally what's at stake. So a lot of these are not fights that we choose, they're fights that we must have because otherwise people lose access to healthcare, lose essential services, lose their safety net. And so that's the work that we're doing right now, is to prevent harm.
Thank you, Omar. So I know that you've alluded to this already, but one area of focus is healthcare. And we've seen that ourselves, especially being in Tennessee with the United States versus Grametti, originating from our own state. So what can you tell us right now about the landscape regarding access to healthcare for members of this community and especially trans people?
Yes. Oof. It's an incredibly shrinking map. So let me add. We're in the year 2026. Prior to 2022, no state prohibited the provision of gender-affirming medical care in any form. Some states had prohibitions on coverage of that care in their Medicaid programs or state plans, but they didn't prohibit the provision of care. So what's new? Let me tell you, it's not the care. This is care that has existed forever. Let me explain. Hormones, as a form of healthcare, first came into the medical establishment and were recognized in the 1920s, 1930s. Since then, hormones have been part of the regimen used for transgender people to live as who they are since the invention of hormones. Same with gender-affirming surgery has existed since the 1930s. There's works that were destroyed as a result of Nazi Germany and institutes that were destroyed as a result of Nazi Germany in that regard. And so this is care that has existed for a long time, right? Harry Benjamin has documented some of this history going back to the 1950s, 1960s, when he wrote his pivotal book, The Transsexual Phenomenon. And the so-called issue of puberty blockers. Well, I'm as old as puberty blockers, and I'm not that old. Puberty blockers came into existence in the mid-'80s. They were discovered, the mechanism in the mid-1980s, and they have been used as a treatment for central precocious puberty since the early 90s, and similarly have been used as a treatment to prevent the development of sexual characteristics in trans adolescents. Mind you, no children is receiving medical care. We're talking people who have hit puberty. There's nothing to do if you don't hit puberty. Like literally nothing. It's just impossible. So they have been used since the 1990s as well. And there's actually research documenting that from the Netherlands and even in the United States that goes back to the 1990s. They like to point to the idea that this is not well studied. I'm gonna shock your mind, because I was shocked when I read this in doing this work, but it made sense. Less than 15% of medical treatments or services that we obtain are actually backed up by what so-called high-quality evidence. less than 15%. But that's the standard that they want to put for gender-affirming medical care. Mind you, what does high-quality evidence mean? Clinical control trials. Otherwise, how we provide research, evidence-based medicine in this country and frankly elsewhere in the world, is through a process of development where we see medicines be approved for one service and we think it may be helpful here, and then we use it there and we think, oh, that might be helpful. Let's study that phenomenon longitudinally and observationally, and that's the type of studies that we see. Those are the studies that exist in gender-affirming medical care, just like in any other form of healthcare. But opponents of medical care for youth, who are the same opponents, by the way, that oppose any transgender person ever transitioning, and I've deposed many of these people, say this is bad medicine, it's not based on high quality evidence. That makes 85% of medicine bad, but okay. And there are no clinical control trials. FYI, if that's the standard, puberty blockers shouldn't be used at all because there's no clinical control trials for puberty blockers for any condition. But that's what they say. Under that guise, several states since 2022, and now we're up to 27 jurisdictions that have done this, including Puerto Rico, have barred the provision of medical care for minors. I'll add that with one or two exceptions, we won every single one of those cases at the district court. Every single one, except for one in Missouri, the vein of my existence, and one in Oklahoma. And why is that? Because, and I'll add that this is before Trump judges, this is before Bush judges, Obama judges, Clinton judges, right? This is not about party politics or ideology. When a judge is a judge, they evaluate the law and the evidence. And so even in Scarametti, Judge Richardson here in the Middle District of Tennessee was the one who issued a decision enjoining the law here in Tennessee. A week prior, he handed me a loss in the birth certificate case, I will add. So it's not that he was a big LGBTQ ally, right? He had literally just ruled against us when it came to the ability to correct the birth certificates in Tennessee. But he evaluated the evidence. And when you look at the expert testimony, when you look at the evidence, it is clear, absolutely clear, that this is care that is safe and effective, and that for the people who need it, and nobody's saying you need to do this, but for the people who need it, it actually improves their lives. And I will tell you that in many ways, I don't say that this is life-saving care. It's not meant to save a life. It is meant to treat gender dysphoria. It's not meant to treat suicide. It is not meant to treat other mental health stressors. But many of those mental health stressors do flow from a lack of recognition of who you are and are tied to that distress that a transgender person may experience because they're not seen as who they are. And so oftentimes, this care can be life-saving. I will tell you one anecdote. In Texas, the state tried to decree this care to be child abuse, just by gubernatorial decree. And we sued, and we obtained an injunction, and that injunction actually still remains in place today. But the Supreme Court of Texas said that injunction cannot be statewide, it's only for your party, so then we had to re-sue with an organization, PFLAG, and extend the relief to all of the members of PFLAG rather than have a statewide injunction. And for all of the law students here, that is what we are also doing with regards to, as a response to Trump v. CASA and the inability to obtain nationwide injunctions, is using associational standing and class actions to extend relief to folks. But we did that, and we did that actually in 2022. This is pre-Trump v. Casa. One of the plaintiffs in that second case, the moment the directive was issued by the governor in Texas, Governor Abbott, and I'm not saying this cost X, I'm saying this contributed to X. He tried to end his life. He was scared out of his mind about being ripped from his family home and about being denied the care that has allowed him to be safe and happy. No parent wants to deal with that. That is what these policies do. And I will add that once he was able to get the treatment that he needed for that episode, he said, no, I want to fight. And that's how he became a plaintiff in our case. And so he's one of our plaintiffs, and we have an injunction on his behalf. But when I hear people say, like, oh, we're trying to protect children, I'm like, which children? You're not protecting the youth that I work with and I talk to. You're hurting them. And so the landscape, going back to the question, is as follows. In half the country, the care is completely illegal for people under 18. And in the other half, the federal administration is doing everything possible to make it impossible to obtain the care by coercing hospitals into stopping the care. And so we have a depleting universe of providers for this care right now. I will also add that the most likely providers to stop the care are the ones that have the most at stake, say big hospital institutions that receive a lot of federal money. The ideal scenario to provide this care, as per the guidelines and what everybody would say, is in a multidisciplinary center, which can only happen in those in an ideal scenario in those institutions. And so they say we need more evidence, but if you shut down the care, how can we study it? And so right now, we have a diminishing supply of care and families scrambling to do everything they can for their children and adolescent children as they move along. We have families that move states. We have families that literally travel across the country from Tennessee to like California or New York to obtain the care that their children need. And that is not where we should be as a country. I will add that with regards to adults, several states are diminishing coverage for that care, and we're starting to see proposals to limit access to that care as well.
Thank you. So the picture that we've been discussing seems pretty dire. Can you tell me about the wins that the LGBTQ community has seen this year and what brings you hope?
Yeah. So in my role at Lambda Legal, I'm a litigator, I'm senior counsel, I'm also the healthcare strategist, so a lot of my work is in the healthcare arena. It also means that a lot of my cases and clients are in the healthcare arena. I get hope from the following things. When I work with families and I see parents that will go above and beyond to ensure that their children have access to the care that they need, including participating in high-stakes national litigation. This is not easy for anybody. And when I talk to them, and I hear their stories, and I see what they will do, how far they will go to make sure that they can fight and ensure that their kids can grow up to be who they know them to be. I mentioned, and I'll pat myself on the back and Lambda Legal on the back, that we're fighting very hard. And so we have 4 injunctions that are still in place against this administration. That is no small feat. That is no small feat. I want to put some numbers to those injunctions. If you recall, I mentioned a coalition of LGBTQ community organizations and health centers that we sued on behalf of to stop the implementation of the DEI and gender orders against them. That resulted in the restoration of $62 million in federal funding to those groups. That is federal funding that has been restored that allows for health services, emergency center, emergency shelter, domestic violence prevention programs, and the like. One of the cases that I'm most proud of is actually our lawsuit against the NIH. And the reason for that is as follows. The NIH decreed that any research having to do with equity or with gender identity is of no scientific value. And as a result, it terminated millions, hundreds of millions of dollars in NIH research grants. And we're talking almost $1 billion being taken away from the infrastructure of health research in our country. Most of that research that was terminated had to do with LGBTQI health in some regard, at least at the beginning. Other had to do with COVID-19 denialism or climate change denialism and the like. Most of the research that was LGBTQI related research, not all, but most, had to do with HIV related research. Our country's story about HIV is not one that starts proudly. We turned our backs on people that were suffering as a result of the HIV epidemics as a country. Lambda Legal brought the first case on with regards to HIV discrimination in the 1980s. We were able to secure access to HIV. The first win saying that HIV discrimination was unlawful in the early 80s. But even then, our federal government denied it. And as many people died as a result of the HIV epidemic that died in Vietnam. The numbers are staggering. But once we committed to studying this disease, and once we committed to doing so, which for the most part meant working with those communities that were most affected, which were the LGBTQI community and people of color, we were able to not only stem this epidemic, but also make incredible discoveries on antiretroviral therapies, on many other things that have actually had permeating effects and have been applied in other contexts, be it cancer research, being other health research. All to say that by doing this research, we were able to help everybody. And now we're stopping it because it relates to LGBTQI people. That is so wrong. And we sued on behalf of CLAMA, an association of health professionals across the country, and 16 individual researchers, health researchers across the country, one of them here in Tennessee. And we were able to secure funding for them. If you're a nerd and you follow some of the Supreme Court decisions about jurisdiction and the American Procedure, the Administrative Procedure Act and the Tucker Act and what court can grant what relief, there's a lot of fighting about which courts can issue what relief under the APA, particularly when it's restoration or involves funding, such as grant funding. Thankfully, we brought other claims, including equal protection claims and non-discrimination claims under the Affordable Care Act. And we have an injunction under those two latter claims that is still in place today, and which, by the way, the administration actually didn't even appeal. As a result of that injunction, over $200 million in NIH research funding has been restored. And research that pertains to age disparities, health disparities in communities of color, research that talks about antiretroviral therapies, adherence with regards to HIV, is moving forward as a result of that injunction. So like I said, I believe in the promise of the Constitution. I believe in the promise of our laws. And you can see them here play out in a way that actually positively impacts people. And we can see that in the people that we work with. I will add that my colleagues at Lambda Legal, at the ACLU, at GLAD and CLR, at the state AG's offices, they're heroes, all of them. We have been working nonstop for over a year. And we will continue to do so. That's what we do. But just to put it in context, I've mentioned seven cases that we've brought now against the administration at Lambda Legal. On top of all of our other cases, we're less than 30 attorneys nationwide at Lambda Legal. And so we count on the support of clinics at universities that we work with and law firms that we partner with, a diminishing number given the attacks to law firms as well by the administration. But we're able to still fight back and fight for the rights of LGBTQ people. And I know for a certainty that what we're living in today is not permanent. I know for a certainty that we're able to get out of this. I know for a certainty too that this is going to be costly in human life, in our well-being, in our own societal understandings. But we can fight our way through this, and I'm certain that we all will play a part in that.
Well, I think that that was a tremendous discussion. So again, we are so fortunate and extremely grateful to you, your colleagues, your team, your coalitions who are fighting for all of our rights. I think we have a few minutes for questions. It's a little bit hard for me to see that clock. But yeah, it looks like we have 5 minutes. So if you have a question, we'd be happy to deliver a handheld mic to you. Just raise your hand, and we have about 5 minutes, so.
We solve the world's problems, we're A-okay. I think there's one there.
I had a question a little bit. You talked a little bit about this in terms of the hospitals kind of pulling gender-affirming care, even though, you know, they hadn't kind of been requested or like legally requested to do this, and that you fought against this. And I'm wondering a little bit about your thoughts about like preemptive compliance from institutions, and how we fight that as well. So like, you know, we are all like in this space, like dealing with this as well as institutions kind of roll back DEI stuff, or, you know, try to make different changes that haven't legally been requested or are currently being contested actively in court. So I'm wondering a little bit of your thoughts about preemptive compliance.
Yeah. Particularly with the hospitals, I think they're caught between a rock and a hard place. And I don't want to pretend that they have an easy choice to make. But a choice is a choice. And, you know, when we talk about law firms, universities, hospitals, we're talking about some of the, frankly, most resourced and richest institutions in our country. And to me, the pre-compliance without any fight whatsoever is the problem. It is the lack of a backbone to stand up for what is right. God, I hate giving kudos to some institutions like Harvard, but I'll give kudos to Harvard for fighting back against the administration. Other Ivies did not do that. Other universities did not do that, right? And so, you know, I think that is important. Some of our law firm partners that got targeted, in fact, for their own work with us, and some of our cases being cited in the executive order for why they were being targeted, fought back, and you know, we supported them in amicus briefs and the like. And so the hospitals have been fighting back, at least to some degree, with regards to the protection of medical records. And I will add that, I know that that was an issue here in the state of Tennessee, but I will add that institutions that have fought back against the intrusion of patient privacy have uniformly been winning those motions to quash in every single district court that has evaluating those subpoenas that got sent to them. But it is an abandonment of a very vulnerable population. I get the abstractly completely unemotionally look at it of like more people here versus few people here, math of it. But at the same time, you could, if you feel compelled to do that, you could also sue the administration. And the fact that they don't do so is a problem. I will also add that there are many institutions that have surprised me as well and have shown a very stiff backbone, including universities that have talked to their Office of General Counsel, and they're like, we will not abandon this population. I'm like, wow, did not expect that from you, but kudos, let's work together. I think it speaks to a lack of valor and a lack of use of resources. And so I will say this. Any corporation that ever tells me that we hold these values, I will not ever believe them again if they don't actively, affirmatively act like it. And we have just seen that writ large. Corporations, universities, hospitals, like so many of these corporations sign on to amicus briefs that was actually some of my work in Bostock, was actually coordinating the business amicus brief with 206 giant businesses, including Facebook and Google and the like, joining that business brief, and then all of them eliminating DEI practices as a result of just Trump saying that he doesn't like it. I think it shows the thinness of the commitment to certain values that certain institutions hold.
So I think we are almost to time, but if we can take maybe one more quick question and then coffee, chat, and birch for anyone who's around. I think we had a question over there, yeah.
Thank you. What is your kind of assessment, either in conversations you've had with people at these kinds of institutions, for that decision not to fight? Like, do they make arguments to you? Do you feel like there actually are kind of legitimate arguments on that side?
What I can reveal is that I think for the most part, people are operating from a place of fear of retribution. And obviously this is an administration that has acted in a retributory manner against several institutions and players. So it is not an unfounded fear. So their thought is, if we fight back, they're going to target us even more. Look, we've seen that with regards to other universities like Penn or Columbia, for example. But I do think that you got to call a spade a spade. At some point, you just got to stand up and fight.
Maybe we have one more super quick question right over there. Yeah.
Hi, my name is Warren. I was just curious, before I even started attending Vanderbilt Law, I was kind of asking members of the administration why we don't have an LGBTQ rights clinic. I was just wondering if you were aware of any LGBTQ legal groups within the state of Tennessee or Nashville that we could partner with in order to make that happen.
Happy to talk with you a little bit further. Happy to have some ideas and for us to talk at the fireside. I think, starting a clinic is hard. So, but there are also ways for people to do pro bono even outside a clinic, and those opportunities can exist even with our own organization. Like, I have research projects I can send you if you need some pro bono hours. Yeah, I think there are institutions in Tennessee that come to mind, but there are different ways to also structure a clinic and offerings like that. So happy to serve as a resource for that.
Well, thank you so much, truly, and thank you for all the work that you're doing, Lambda's doing, and everything. I think this was a great discussion. Can you please join me one more time in thanking Omar?